I'm going to show you what's been marked as States 452 and see if you recognize that document.
Yes, sir. This is a snapshot of text communications between me and Alec that I snapshot and provided.
All right. Your Honor, this time I'd move States 452 into evidence.
No objection.
Submit it. 452. This is a screenshot of the text that of your text that you provided. Is that correct?
Yes, sir.
All right. And we see down at the bottom, is that a text? Who is that text from?
That's from Alec to me at 9:52 on June the 7th. It says, "Call me if you up."
Okay. Did you receive that text? Were you still awake at that point?
Yes, sir, I was.
All right. And what did you do?
Picked up the phone and gave him a call.
Okay. And tell me about that conversation.
Um,
Call it one time or two times?
No, I called. The first time I called, he didn't answer, which is kind of normal with Alex sometimes. Sometimes he wouldn't answer because he was either on the phone or sometimes he was just in bad service, I think, and couldn't get a call to go through. So I'm pretty persistent. I call right back. So I called him. I didn't get an answer, and then I called him back. And that was at 9:50. According to these records, 9:52 is when I tried to call and didn't get an answer, and I called back at 9:53 and said, "Hey, Alec, I got your text calling you back. How's your mama?" And he said, she's, doing about like normal, I think. I mean, she'd been doing poorly for years. And I told him I needed to talk to him. We had a case we were working on that involved a piece of equipment that had malfunctioned, and the company had preserved the equipment, but they weren't going to preserve it too much longer. We needed to get it inspected, and they were kind of pushing on us about when the inspection was going to occur. And I said, "Hey, we need to talk about this and get this squared away so we don't miss the chance to inspect this equipment, and I need to talk to you about some motions or something I've got upcoming that I need a little help on." And he said, "Hey, that's cool, but I'm about to get back home. Can we talk tomorrow?" And I said, "Sure, fine."
That was some total of what he had to say was he's about to get home to Moselle and can we talk tomorrow, correct?
Yes, sir.
We put States 451 up on the screen. And right here, is that your writing right there?
That's my handwriting, yes, sir.
And that says Alex M., and those are the defendant's calls, is that right?
The bottom one is him calling me and me telling him I'm on the pool pump. Mm-hmm. The next one is me calling him back and telling me he's about to get to his mama's. Mm-hmm. And then the next one up here is me trying to call him after that text that he didn't answer. And then the top one is me calling him back after he didn't answer and talking to him for those couple minutes.
And then that one in the middle, that's just an irrelevant conversation with some other person?
Just a friend of mine who I told his name was probably coming out today. So I told him that he was on my phone.
We did scratch out his number.
That's right, yes, sir.
Now we did.
Yes, sir. I just felt like his name would probably come up today, and he should know that.
Just go about your evening after that? Did you just go about your evening after that?
Pretty shortly after that, I went on to bed. My wife stayed up, but I went on to bed shortly after that.
How'd you find out?
I was asleep. My phone's always kind of sit beside the bed. I could hear it buzzing, but I really wasn't paying any attention. My wife comes in kind of, just hysterical. She says, "You got to wake up, you got to wake up." And I, I don't remember if she was on the phone with Randy's wife or Randy himself. She's trying to tell me what's going on, and I'm looking at my phone, and I've got a text from a person I knew in Hampton that's texting me saying, "Hey, give me a call. I got to tell you something before you hear it somewhere else." It was a person that was in the county government down there that I knew that was just trying to get word to me before I heard it somewhere else. My wife, I don't think I respond to that person or her text immediately. My wife's telling me what's going on. I just told her, I said, I'll get some clothes. I got to go to Moselle. We started trying to call our daughter right at about 11 o'clock. Started trying to call our children, tell them what was going on. I don't even know how much my wife and I spoke about it. I mean, she knew I was leaving. I got in the car, went straight to Moselle, grabbed some clothes, and went straight to Moselle.
How long does that take?
From Columbia, about an hour and 40 minutes or so. I mean, I called some different people on the way that I thought needed to know. I mean, repeatedly tried to call my daughter. She was extremely close. She is and was extremely close to Buster and Paul. And, you know, we couldn't get her to answer, called her boyfriend, just repeatedly calling her. I think I talked to Randy on the way down, but I can't say for sure I did, but I know I talked to somebody in their family on the way down, just to tell them I was on the way.
About what time did you get to Moselle?
About 1 o'clock in the morning.
Other family and friends were arriving then too?
Already had arrived, I believe, yes, sir. I mean, when I got there, I went through the main gates. I could see, I don't know that I knew at that point that this had occurred at the kennels, but I could see that there was tons of activity there as I passed by to go to the main gate, and when I turned in the main gate, I was on the road headed up to the house. You don't go very far and you can turn right to go to the kennels. I almost was going to turn and go down to the kennels, and I think John, Marvin, and Randy were walking out and kind of waved off and said, "Go to the house."
Is that where you went?
Yes, sir.
Was the defendant there?
He was, yes, sir. Yeah.
You talked to him?
I did. I walked in, hugged his neck, and cried. Didn't know what to say.
Hugged his neck and cried.
Yes, sir.
A lot of people there coming out to support him, as you would expect, correct?
Yes, sir. There were a lot of the lawyers that he practices law with, several family members, you know, some friends of his that I knew. There were a lot of people already in the house, yes, sir.
Did you stay there during the early morning hours as a friend, supporting your friend?
Yes, sir, till 5:30 or so in the morning. 4:35, I don't know. I mean, everybody was shocked and destroyed, and I mean, times it felt like it stood still. So I don't know exactly what time it was, but sometime 4 or 5 o'clock that morning, everybody decided it would be best for Alec and Buster to go get some sleep, or at least try to, and not stay there that night. And so I went back to Bamberg and slept in my office.
Did you return to Moselle the next day after getting some sleep?
I did, about 9 o'clock that next morning.
Were you there as much as you could be at Moselle or wherever you were needed over the next few days in the aftermath of all of this?
Yes, sir. I was there almost entirely the next 2 days.
At any point, did you ever have any conversation with the defendant about what he did that night?
Not really, no, sir.
What do you mean by not really?
I mean, I didn't ask him. I didn't want to know what he found. I didn't want him to have to describe that to me. I didn't want him to have to relive it, so I didn't ask him about it.
Didn't ask him about it?
No, sir.
It's only natural.
Yes, sir. I mean, I was there as a friend, supporting him and his family. I didn't need to know the details. I knew all I needed to know is that two people that I loved were gone.
Certainly weren't going to ask him about the stupid issue with the fees in this time.
No, sir, not at all. Didn't know there was an issue with the fee. I mean, I did not know there was an issue with the fee at that time, so I didn't have anything to ask him.
Over the next few weeks, did you do what you could do to be a supportive friend?
I did. Yes, sir. I mean, I tried to call him even more often. If I was anywhere close to Hampton, I tried to stop by and check on him. I tried to make him go places and do things. Not much, but I felt like he needed to get out. You know, just, I mean, I was worried he was going to hurt himself. I mean, I was worried he was going to kill himself, just like I think a lot of people were, family and lawyers, his partners. And so I think we all talk regularly about keeping an eye on him, and about being there for him.
After a few weeks go by, the shock starts to abate just a little bit.
It still hadn't abated.
Still hasn't abated, just a little bit.
Yes, sir.
At some point, does the defendant call you about those fees?
He does. Yes, sir.
You remember roughly when that was?
Sometime around the middle of July.
What does the defendant say to you?
He tells me that he has not been able to put the monies into the annuities like he thought he could, that he's messed it up, and that the monies needed to be paid to his firm, and that that he needs to send the money back to me to run it through my trust account to write the checks to his firm directly.
Do you remember how that conversation came up?
I don't remember exactly how it came up, no, sir.
But he contacted you to say, hey, I messed up those annuities, I need to send the money back to you, correct?
Yes, sir.
Did he send the money back to you?
Not all of it, no, sir.
What did he send back to you?
$600,000 of the $792,000.
And in what form did he send that money back to you?
It came in the $600,000 came in two separate wire transfers.
Tell me about those.
I don't remember the dates, but I think it was July 15, July 16, somewhere around in there. One came from Palmetto State Bank, and I think one came from Bank of America.
One for $350 and one for $250, correct?
Yes, sir, I believe that's right.
That was only $600,000, correct?
Yes, sir.
And you had dispersed to him directly how much?
$792,000.
Did you have a conversation with him about the fact that it was $192,000 short?
Yes, sir.
And what was that conversation?
He told me that he had already put the $192,000 away to where he wasn't going to be able to access it. I took it that he had already put it into the annuity and that it wasn't going to be available without some type of penalties or cost. And he said, I don't have the $192,000, but I'll be able to get it to you very shortly or soon. I don't remember if he said within a couple days or a couple weeks or what he said, but it was soon.
What did he want you to do, though, once this money came back in? Did he ask you to do anything?
To rewrite the checks payable for the fees to his firm.
Did he ask you to communicate with the firm at all?
He asked me when the money was back into the account if I could send an email that I was holding those monies so that they would know those monies were in the trust account.
All right. But you're $192,000 short, so what was his discussion then?
He asked me, he told me he didn't have the $192,000. And I mean, at that point, I know that I've got a trust account for which I'm responsible for. I've got money that's supposed to have been in my trust account payable to his firm for fees. That's my responsibility. And so I had to put $192,000 of my own money into my trust account to hold for the fees for his firm.
And how did you do that? How did you put $192,000 of your own money into your trust account to cover the defendant?
I wrote a check for myself and put it into my trust account.
And just quickly, explain to the jury why you have to do that. What is it about a trust account that you have to do that if you're going to send that email to the firm?
Because I can't tell somebody I'm holding money in my trust account that I'm not holding in my trust account. I'm responsible for that trust account. Trust accounts are money that belong to someone else that you're holding in a fiduciary relationship, and you're responsible to make sure that those monies are held and dispersed appropriately. And at this point, I'm hearing that I haven't dispersed or paid those monies the way they're supposed to be paid.
At that point in time, did he ask you to cover that money, or was that just kind of a given that he was short?
I knew I had to, and I think he asked me to, but I knew that I had to.
So you get the $600,000 from the two wires, and you write $192,000 of your own money,
Yes, sir.
and then you send an email to the law firm. Is that right?
I sent an email to Alex,
To Alex?
yes, sir, that he tells me he's going to forward to his firm, which I, ultimately found out that he did forward to the bookkeeper and one of his partners.
I'm going to show you States 349, see if you recognize that.
Yes, sir. This is an email I sent on Monday, July the 19th, 2021 to Alex.
Is that the email you're talking about?
Yes, sir.
All right, this time I've moved States 349 into evidence.
No additional objection, Your Honor.
Admit it. Can you read that email to the jury, please?
Sure. Alec, as discussed, I'm confirming that I am holding in trust $600,000 in the, and that's just redacted to take the gentleman's name out, the gentleman's case, and $192,000 in the, and that's redacted out to take out the wife's name, in the wife's case, which represent attorney's fees. I will continue to hold these monies in trust until I am instructed by you or your firm regarding payment.
After you sent that email, did the firm contact you? Did you have to disperse the money, or did that just kind of end the matter?
Not until September the 3rd, when Lee Cope called me after they claimed that, after they stated that they had discovered that Alec was stealing money.
Well, let's talk about the interim. But at that point in time, you sent that email, and nobody's making any further inquiry at that point in time. Is that correct?
No, sir.
And that money's just sitting there,
Sitting in my trust account.
including your personal 192 that you wrote to cover Alec, correct?
Yes, sir.
Did you ever have a conversation with Alec about when he was supposedly going to get you that money?
Yes, sir.
Tell me about that.
I know we talked about it one time. I think it was at the August convention down in Hilton Head that most of the lawyers that do what we do attend. I had begged Alec to come down there and for Buster to come with him at least one day to play golf with some of us so they'd get out and do something so Buster could do something normal. And I think it was while we were playing golf that I just said, hey, where do we stand on you getting me repaid? He told me that, I knew that Maggie's estate would be tied up, and I figured that that was a delay. He told me that he was, moving towards selling some property and that his father had obviously just passed, and that there would be some monies coming to him from his father's estate, and that he was working on it, and he was trying to do it as quickly as he could. He apologized for it taking longer than he said it would.
And he told you that he had tied up some money in structures or something like that, and that's why he couldn't get to it right then?
That's what he told me, why he couldn't get the $192,000, because that he had already put it into, the way I understood it, he had already put it into the annuity and couldn't get it back out. I think once you put those monies away, as my understanding is, you can't just pull them right back out. It's not like a checking account or a savings account where you can deposit and withdraw immediately.
But that's what he's explaining to you, correct?
Yes, sir.
So that conversation you had with him at the trial lawyers conference playing golf, that was when, roughly?
First weekend in August. Actually, it'd probably be that we normally try to play golf on that Thursday, so whatever the first Thursday in August is.
Not long after that, did you have another conversation with him about the money that you had covered for him?
I did.
And roughly when was that?
sometime shortly after that, middle of August maybe, I called him up and said, I need to come see you and talk to you about something, and I went down and talked to him about this money. But it wasn't it was about the money. I needed to be repaid. I mean, that's a lot of money to me, and I wanted to be repaid.
$192,000, that's a lot of money.
Yes, sir.
A lot of money to anybody.
Yes, sir.
I'll show you what's been marked as States 350. You recognize that?
I do.
And what is that?
So,
What's the date on that first?
August 17th of 2021.
Your Honor, at this point, I'd move States 350 into evidence.
No additional objection.
It's admitted.
All right. Tell me about that document. What happened? What's the conversations related to that document?
At some point in time when I'm talking to Alec, I said, hey, I need to come see you in your office and talk with you about something. I don't even think I told him exactly what it was. He said, sure. So I went down and went in his office. I said, look, I hate to even talk to you about this, and I hate to ask you this, but if something happens to you, and I think I phrased it like if you get hit by a car or something happens and you die, I can't get repaid that money against your estate unless there's something in writing between us. I knew enough to know, enough of the law to know that you can't enforce an agreement with a person that's deceased against their estate unless you got some documentation of it. I said, boy, I hate to even ask you to do this. And I was worried that he was going to kill himself, still at that point. And I was worried about what that would, mean, more so on a human personal level, but also what that would mean about me trying to get repaid. And I said, I hate to ask you to do this, but can we do this? And he said, sure, no problem. I mean, that's our agreement, and sure. And so we scratched out, he hand wrote it, 3 sentences, nothing formal or fancy.
This is on what day?
August the 17th. And I was in his office.
Hold on for me 1 second.
I'll stand for a moment. conference, isn't it? Ladies and gentlemen, we have you go to the jury room for recess. Please do not discuss the case.
No, I just, out of an abundance of caution, before we got to this portion of the witness's testimony, as Your Honor is aware from the in-camera proceedings, there is, he has a confrontation with the defendant, and the defendant tells him some things that he... the witness here has a confrontation with the defendant at his mother's porch after receiving word about what the law firm had found. From the in-camera testimony, the witness has testified that the defendant, admits the financial misdeeds, says he had a drug issue, I think going to rehab, and some things like that. And that is, I believe, on the early afternoon of September 4th. And then not long after that, he hears that the defendant was shot on the side of the road. And so we've had some discussions about the drug issue. So before listening to that testimony, I alerted the defense and wanted to make sure that we had set our ground rules on that. And then, of course, the side of the road issue, which we've talked about earlier.
What ground rules did you set?
Your Honor sets the ground rules, and that's.
You take a break during questioning the witness to have a conference with counsel.
Well, I am seeking to admit that evidence, not only of what the defendant said about his drug use, but also to submit that not long after that he heard about the side of the road incident, and I, out of abundance of caution, raised that issue, and I believe the defense was going to object. Trying to give them the opportunity to do that in an in-camera setting.
All right.
Your Honor, for both of those, I think they are admissible. First of all, again, we're not offering any drug use, and we've had some discussion about that yesterday. We're not offering any drug use for the purposes of what's improper under 404. In this particular instance, the defendant himself identifies that as a reason for these alleged misdeeds. So not only is it not 404, it's just part of the res geste of his statement, which is part of what's been admitted.
It was admitted yesterday, so we're beyond that issue as far as the court is concerned.
All right. And then as far as the side of the road,
of which have not been disclosed, but the email from Mr. Murdaugh doing rehab was published by the defense.
Yes, sir. And then secondly, along with the side of the road, again, at this point in time, I'm just going to be admitted that he heard about what had happened to the defendant. There are other circumstances that we talked about earlier that we would address at a later time. About the side of the road, which we believe is admissible and admissible under 404. We could I don't know that we need to have an in-camera proceeding at this point in detail about that, but because all he's going to say is he heard that happen, but I just wanted to, again, and out of abundance of caution, we've gone this far. I just wanted to be, before I elicited anything along those lines, just wanted to alert the defense and give them a chance to object.
All right. Mr. Griffin?
Yeah, we do object, Your Honor. First, he's not the proper witness to be testifying about what happened on the side of the road. He just hears it secondhand, so any information he has is just hearsay. In the in-camera hearing, he also provided his opinion that Alec must have tried to commit suicide, and that's improper. So first it's hearsay, but more importantly, Your Honor, it is a bridge too far under the narrow exception that you've offered, that they're offering this evidence of financial crimes, that is a motive for this alleged murder that he committed. And so the fact that whether it was an assisted suicide or they want to go further and say it's part of the same scheme and that it's a sympathy ploy, which the court hasn't ruled upon, and we don't think it meets the standard there, and it violates Rule 403. So for all those reasons, we object to it coming into evidence.
Do you want to proffer what Attorney Wilson is going to say about it?
I believe during his prior testimony in the in-camera hearing, and I certainly can do that, he testified.
I recall his prior testimony.
Yes, sir.
Which did not involve anything about a roadside shooting.
Well, and so I'll go ahead and proffer, Your Honor.
Yes, sir.
All right. So, Mr. Wilson, kind of jumping ahead, you had a confrontation with the defendant on September 4th when you drove to Hampton County to have a meeting with him on the porch of Alameda. Is that correct?
Yes.
All right. And pull the mic forward to you a
Yes.
little bit. And without getting into all that detail, after that conversation, he made some admissions to you at that time. Is that correct?
Yes, sir.
And just very quickly tell the court what he said.
He admitted or said that he had a drug problem for 20 plus years, and that he was going to rehab. And then he said he admitted he had been stealing money.
Okay. And did he say anything about the 192 with you? Did he have a phrase he used for that?
Yes, sir.
What did he say?
You don't have to proffer this portion. You're indicating you're trying to go beyond this into something else.
What time did this, yes, sir, thank you, Your Honor. What time did this conversation take place, roughly?
Late morning, just before lunch.
All right. And that's on September 4th?
Saturday, September 4th, yes, sir.
After that confrontation, did you leave?
I did.
And where did you go?
I went through Hardee's in Hampton, grabbed a bite of lunch at the drive-thru, and then drove back towards Columbia.
Did you hear about anything relating to the defendant within a couple hours?
I did. I got a phone call from Lee Cope. Might have been Randy, but I think it was Lee Cope that called me and said Alec had been shot in the head and was being helicoptered. I thought he said to Savannah Hospital. I know he said to the hospital in a helicopter.
That's as far as this witness would go.
And I've sustained the objection as to this portion of the testimony. I agree with the defense's hearsay, and if it's and he's not the appropriate witness to testify on this issue.
Thank you, Your Honor. So obviously, yeah, all right. And you're a lawyer. You understand where to stop.
Yes, sir.
All right.
We'll take a recess for about 10 minutes.